Employment law in the United Kingdom continues to evolve in response to changes in the modern workplace. Governments regularly review legislation to ensure that employment rights remain fair, balanced, and fit for purpose. Between 2025 and 2027, several reforms are being introduced to strengthen worker protections. These reforms focus on improving statutory sick pay eligibility, strengthening protections for pregnant employees, updating parental leave rights, and addressing controversial workplace practices such as fire and rehire. According to official guidance and policy announcements referenced by ACAS and Gov. UK, these changes are designed to improve job security, fairness, and workplace stability across the United Kingdom. In this overview, we will examine the key reforms expected to influence employment law during this period. Section 1 expanded statutory sick pay eligibility. One major reform focuses on statutory sick pay, often referred to as SSP. Statutory sick pay is the legal minimum payment employers must provide to eligible employees who are unable to work due to illness. Historically, eligibility for statutory sick pay has been restricted. Workers must normally earn at least the lower earnings limit, and payment typically begins after several days of absence. Recent reforms aim to expand access to statutory sick pay, particularly for workers on lower incomes and those in insecure forms of employment. Policy proposals referenced by Gov. UK employment reform guidance suggest that future changes may include broadening eligibility for sick pay to include more workers, removing certain barriers that prevent lower-paid workers from qualifying, improving financial security for employees who must take time off due to illness. These reforms aim to ensure that workers do not face financial hardship when they are genuinely unable to work due to health reasons. From a public policy perspective, improving access to sick pay also supports public health objectives because workers are less likely to attend work when ill. Section 2 strengthened protections for pregnant employees and other. Important area of reform concerns pregnancy and maternity protections. Under existing UK law, employees already receive protection against discrimination due to pregnancy or maternity under the Equality Act 2010. However, new reforms seek to strengthen these protections further. Government policy developments indicate increased safeguards against dismissal or unfair treatment during the period surrounding pregnancy, maternity leave, and return to work. ACAS guidance emphasizes that pregnant employees must not be treated unfairly in areas such as recruitment, promotion, training opportunities, redundancy decisions, workplace conditions. New reforms aim to strengthen protections against dismissal during pregnancy and in the period following maternity leave. This ensures that workers who become parents are not placed at a disadvantage within the workplace. These protections support workplace equality and reinforce the principle that family responsibilities must not undermine employment security. Section 3 changes to parental leave rights. Parental leave rights are also undergoing important changes. The UK already provides several types of statutory leave for parents, including maternity leave, paternity leave, adoption leave. Shared parental leave reforms expected between 2025 and 2027 aim to make these rights more flexible and accessible. Government guidance highlights efforts to improve the ability of parents to balance employment with family responsibilities. Possible improvements include increased flexibility in how leave is taken, enhanced support for parents returning to work, stronger protections against workplace discrimination related to parenting responsibilities. The goal of these reforms is to create a modern employment framework that recognizes the importance of work-life balance and family stability. Employers are encouraged to adopt policies that support parents while maintaining business continuity. Section 4 tackling fire and rehire. Practices. One of the most widely debated employment practices in recent years has been fire and rehire. This practice occurs when an employer dismisses employees and then offers them new contracts with less favorable terms. In some cases, this has been used to reduce wages, alter working hours, or remove benefits. Concerns about this practice have led to increased scrutiny from policymakers, trade unions, and employment law experts. In response, the UK government introduced a statutory code of practice on dismissal and re-engagement, which is referenced by ACA's guidance. The code aims to ensure that employers consult employees properly before making contract changes, explore alternatives before dismissal, provide clear justification for proposed changes, Engage in fair negotiation with staff representatives. Employment tribunals may consider whether employers followed the code when deciding cases involving dismissal and re-engagement. Failure to follow proper consultation procedures can result in increased compensation awards in tribunal claims. The aim of these reforms is to prevent misuse of the practice while still allowing businesses to restructure when genuinely necessary. Section 5 Wider Goals of Employment Law Reform. Reforms taking place between 2025 and 2027 reflect broader objectives within UK employment policy. These objectives include strengthening worker protections, promoting fair treatment in the workplace, supporting families and working parents, ensuring businesses operate responsibly, reducing insecure employment practices according to ACAS guidance. Effective employment law must strike a balance between protecting workers and allowing businesses to remain productive and competitive. These reforms aim to modernize the UK employment framework while maintaining that balance. Conclusion: employment law in the United Kingdom continues to evolve to reflect the needs of both workers and employers. The reforms expected between 2025 and 2027 focus on expanding statutory sick pay eligibility, strengthening protections for pregnant employees, improving parental leave rights, and addressing controversial employment practices such as fire and rehire. Together, these changes aim to create a fairer, more secure, and more modern workplace environment across the United Kingdom. For employees, awareness of these rights helps ensure that workers can recognize when protections apply to them. Guidance on employment rights and workplace responsibilities can be found through official sources such as ACAS and Gov. UK, which provide authoritative information on UK employment legislation. Thank you for taking the time to watch my videos. If you enjoyed them, please like and share this video.